So, good afternoon, everyone, and thanks for joining this session on what HR need to know about the new points-based immigration system. I thought I'd start with the background to the changes. So, at 11 o'clock on the 31st of December 2020, the Brexit transition period will end, and that means the end of freedom of movement and the end of the free flow of European workers into the UK to live and work. We've had the benefit now of, well, by the end of the year, it'll be an 11-month transition period, which was effectively a standstill period where nothing much changed in relation to the rights of European nationals to come to the UK to live and work. So that's kept things the same, but that's all going to change at the end of the calendar year. And employers right now have got just over 3 months to prepare for the end of the Brexit transition period. And at the same time, the new points-based immigration system is going to come into force from the 1st of January 2021, which is a new, simplified and also expanded immigration system that will apply equally to European nationals and individuals from any other countries alike. So hopefully now is a good time to get ready for those changes and to familiarise yourself with what is changing. In terms of where we are with the rules, in February 2020, the government published its policy statement on the new points-based immigration system, and that was to set out the key parts of the system. Since then, we've had further detail in the new rules in the form of a further detail statement, which was last updated on the 4th of August. And that gives us quite a lot of information about the new rules that we'll cover today. But it's worth mentioning that there's further guidance for applicants to come. There's also going to be new immigration rules published and secondary legislation to come as well. So we'll provide further blogs and updates on those changes as and when they come out. But today then, the agenda is, I'm going to start by kicking off about the skilled worker route and intra-company transfer route. I'm going to look at the before and after, so the current rules as compared to the new ones. And I'll touch on some of the changes to the eligibility criteria. I'm also going to look at the process, timing and costs of sponsoring employees to work in the UK. My colleague Erin McClafferty is then going to talk about some other parts of the points-based system other than the skilled worker route and intercompany transfers, but some of those which employers might want to take note of or be aware of. And she'll finish off by covering some key takeaways from the session. So, as I said, I thought it'd be helpful to just compare and contrast the old with the new so that you can see what's changing, and the actual changes to the rules are in bold on my slide. So at the moment we've got Tier 2 General, and that is a route for employers to bring international recruits to the UK, and that's for skilled workers who've got a job offer. So in every case they'll have to have a job offer in order to be eligible under the rules. That allows them to come to the UK for up to 6 years initially, but it can lead to settlement after they've been living and working in the UK for 5 years normally. There are mandatory English language and maintenance requirements, and that piece is staying the same under the changes. But what's important to note is at the moment, in most cases, a resident labour market test will apply before the employer is allowed to sponsor somebody. And that usually involves advertising the job for 28 days in accordance with specific requirements, and the employer demonstrating that they can't find a British or European national who meets the essential requirements for the job. And in terms of what's changing, that's one of the key requirements that is going, which is great news for employers in terms of not having to go through the timescales of advertising for 28 months, for not having to keep paperwork to do with that. And it will always also provide employers with more certainty in terms of who they're able to sponsor at the outset of the process without having to jump through that hoop of testing the resident labour market. At the moment, Tier 2 General is only for the most sort of highly skilled jobs, and there is a minimum salary threshold of either the higher of 30,000 or the going rate for the job as determined by UK Visas and Immigration, and the minimum salary levels are all published on their website for that. So if we look across to the second part of the slide in terms of what's changing in relation to that, one of the key changes is that the route, the skilled worker route, so it's being rebranded and renamed, it will no longer be called Tier 2. As I mentioned, the resident labour market test is going. Medium skilled jobs will be eligible for the first time, which will significantly expand the number of roles which will be eligible for sponsorship. So instead of that being at kind of A-level type entry requirements, and instead of that being at graduate level entry requirements, it will be A-level type at that RQF level 3 or above, and the Migration Advisory Committee sort of assess jobs to determine which fall within which skills level. There'll be a significant reduction in the minimum salary needed down to 25,600 or the going rate for the job. So again, increasing the number of jobs which will be eligible for sponsorship. And another important change is that the immigration cap is going. So at the moment for Tier 2 General, there is a limit each month, and there's an annual limit of just around 20,000 people who can be sponsored under this route. That immigration cap is being suspended. It will no longer be relevant, and that's good for two reasons. One, because again, it gives the employer more certainty that they can sponsor the people that they want to. They don't need to consider who else is applying that month and how many other people are applying for certificates of sponsorship. And secondly, it will cut out about 4 weeks of process time. And that's because of the current process that's currently in place for applying through the immigration cap on a monthly basis. And I'll come on to talk about that. Another key change just at the bottom of the slide then is that there'll be a special health and care visa. This has been in the press a bit, and that's going to be a fast track, lower cost visa for certain healthcare workers. So I'm not going to go into that in detail, but just worth bearing in mind that that exists. So to drill down a little bit more into the minimum salary requirements, on my last slide, I guess I'd mentioned the main drop down to this minimum of 25,600, but there are various exceptions to that. There's always lots of exceptions to the rules. And this slide basically sets out the way or the circumstances in which you could pay less and still have a job which is eligible for sponsorship. So if the job is either on the shortage occupation list, and that's a list of jobs which are deemed to be in short supply by the Migration Advisory Committee, or if the person has a PhD in a subject which is relevant to the job in question, or if the person's got a PhD in a STEM subject, even better, which is relevant to the job in question, then the person will qualify for what's called tradable points. And that means they can be paid less than the minimum salary threshold, and they will still qualify for sponsorship. So main point of this slide is that don't, I guess, assume that a job's not eligible just because it falls under that 25,600. It's worth checking the nitty gritty of the rules because it may be possible still to go ahead with sponsorship, even if somebody's paid less if one of those circumstances apply. And the UK Visas and Immigration have set out which jobs PhDs are relevant for, but the employer is also to make an assessment about that too. My next slide sets out some other exceptions whereby you can pay less. There are rules for what's called new entrants, and we currently have new entrant rules under the Tier 2 General system, but those will also exist under the new skilled worker route. And again, situations where you can pay less than the minimum salary, those are for people who are generally younger, possibly in their first job. So anyone under the age of 26 qualifies, or individuals who are either switching from student visas or from the new graduate route, which Erin will come on to talk about, or people working towards certain qualifications. So if it's a recognised professional qualification, they may be eligible for these new entrant rules, which means they can be paid less. And in general, that's a 30% reduction than the experienced worker rate for the job. But UK Visas and Immigration set out what the specific minimum salary requirements are for them. But again, just worth bearing in mind, if you've got a lower paid job, that might be relevant. So I'm now going to move on to talk about Tier 2 intracompany transfers. So we have that at the moment, and that's going to be rebranded or rebadged as the intracompany transfer route. So this route generally, there's less that's changing. It's actually the most commonly used route at the moment in terms of sponsorship by employers, because there's lots of advantages to intracompany transfers, which may no longer be relevant under the new rules, and I'll come on to talk about that. But basically this route is for international group companies who've got a business in the UK, but they'll also have a business overseas somewhere. to bring someone over into the UK, usually for a temporary period. That can be up to 5 years in many cases, or 9 in limited circumstances, depending on the person's salary. But it's not a permanent route to settlement at the moment. It should be for a temporary assignment to the UK. It is currently for highly skilled jobs, and that's at that RQF level 6 or above. And the critical benefit at the moment is that no resident labour market test is required if the individual's worked for a year for a group company overseas. And another benefit is that there's no English language requirement applicable to this, but there's a higher minimum salary threshold of 41,500 or the going rate for the job. So going forward, we'll still have an intra-company transfer route, and for those employers who want to be able to access this, you've got to apply for it when you to be added when you apply for your sponsor license, or you can add it at a later date. But the key things to note in relation to the changes are it will remain only applicable for highly skilled jobs. So the medium skilled jobs that I talked about before will not be eligible. The minimum salary of 41,500 is staying the same, so that's not going to drop down. There will be changes, although this will remain a temporary category. Individuals will be able to switch into the skilled worker route from it whilst remaining in the country, which is a change to the current rules. So that's good in terms of adding flexibility for employers. And I'd mentioned before it might be used less than it is at the moment, because I guess the main benefit of this was always that you didn't need to run this resident labour market test. But once that's disappeared from the skilled worker route, that key benefit will have fallen away. So I don't think it will be used as much in the future as it is now. But the circumstances in which I can see it being used is where somebody doesn't meet the English language requirement for the skilled worker route, because that will remain a difference between the skilled worker route and intra-company transfers. So I'm now going to move on to talk just briefly about process timing and costs. Again, the before and after. So the current process and timing, just briefly on that slide. So we've got 5 stages or 5 steps towards sponsoring somebody to work in the UK at the moment. That's to either apply for or have a sponsor license in place, which is the critical bit that can take time if you don't have it in place. Secondly, checking the eligibility criteria, so checking if the job's skilled enough and paid at the appropriate rate, and in many cases then to go ahead and run this resident labour market test for 28 days. That's the bit that's going to change, and that 4-week period should fall away from the process, as you'll see in a minute on my next slide. The next step is to apply for a certificate of sponsorship for the individual. And under the current rules, we've got 2 types, restricted and unrestricted, depending on whether the immigration cap applies to that category of individual. And the significance of this is that at the moment, if the immigration cap applies, you need to apply through this monthly allocation process for one of the certificates of sponsorship, and that can delay things by up to 4 weeks. Again, that part of the process is going to fall away, so saving employers a further 4 weeks in terms of process. This distinction between unrestricted and restricted certificates of sponsorship will sort of disappear. And at the moment, the next stage would be for the individual to apply for a visa and then wait for the outcome. The main differences in terms of future process are you still need the sponsor license. The eligibility criteria will be a little bit different than before, as I've outlined, but we won't have this difference between restricted and unrestricted certificates, and we won't have this monthly allocation process to go through, but the bit about applying for the visa and waiting for the outcome will be the same. But overall, the process should be much faster, up to 2 months faster, more certain and simpler, which is great news for employers. So the key messages then, sponsorship will be quicker and more certain. There'll be less paperwork, admin and record keeping, so not having to do the resident labour market test, which usually involves lots of paperwork, which then from a compliance perspective needs to be kept on file. All of that's going to fall away. So overall, lots of good messages and good news for employers, but having the licence in place is the gateway to all of this, and that is the thing that we find, I guess, clients have a problem with. If they've not got the license in place, they then find someone they want to sponsor quickly, and that's the thing that takes time. So the message to take away from that is to get the license in place. Will the employer costs change under the new system? Well, the answer to that is that the costs per head will be largely the same, and I've put up onto the slide some employer and employee costs. Some employers will pick up some of the employees' costs for them. But overall, sponsorship is quite an expensive process when you add all of the bits together. There's a fee for the certificate of sponsorship, a fee for the visa, there's the immigration skills charge, which is up to £1,000 per head, per person per year of the visa, so that can be a £5,000 charge for a 5-year visa. And there is, of course, also the immigration health surcharge. The only bit about that which is changing is that the immigration health surcharge is going up from the 1st of October to £624 per person per year of the visa, and that's also needs paid for each member of the family who may be accompanying the sort of sponsored person. But the main difference is that going forward, employers are likely to have to budget more for increased immigration costs because they're going to have to sponsor more people. So any European nationals previously would have been cost neutral. They didn't have to pay the immigration health surcharge or the immigration skills charge, but all of those costs will apply going forward. So if you're going to be sponsoring those medium skilled workers or the people, I guess European workers who previously didn't need that, that's where the difference will lie.
Thanks, Elaine. So I'm now going to quickly run through some other changes to the points-based system. While Tier 2 and the skilled worker visa route is the area that's subject to the most changes under the new rules, there has been some reform to the system as a whole. So I'll quickly run through some of these and highlight some of the key things that employers should be aware of from the 1st of January. So the first one is that there will be no low skilled route. So the medium and highly skilled roles will continue to be sponsored under the skilled worker route, but there will not be an option for lower skilled jobs. So it's important for employers to be aware of that. And if they're reliant on EU and Swiss labour in relation to those roles, they should just be aware that there may be a gap going forward. The other change is the opening of the graduate route. So this is for students who are graduating from the summer of 2021, and it will allow these individuals to stay in the UK to look for work or to undertake work for a period after their studies. So this is 2 years for people that are studying a normal degree and 3 years for those studying a PhD. But after that period, these individuals will require to be sponsored. So if as an employer you end up employing an employee on a graduate route visa, it's worth bearing in mind that you may be required to sponsor them in the future, and having a licence in place will make that process so much easier when the time comes round. There will also be an unsponsored route which will be opening. At the moment we don't have a lot of information on this and we don't know exactly when it's going to open, but for employers who don't have a licence, this may be an option as it doesn't require sponsorship by an employer, but it depends on the criteria which are still to be announced on that route. Global talent will also continue to be in place and will be extended to EU and Swiss citizens. It's important for employers to be aware of this, as although they don't sponsor the migrants under this category, it is possible for an individual to receive endorsement from a third party, so it has to be in a qualifying field. They receive endorsement as a leader or an emerging leader, and they can then go and undertake roles in the UK. So it is very possible for employers to have staff who are employed in the UK but under a global talent visa. So this may be one that you come across from time to time. And for completeness, I'll just briefly mention startup and innovator routes. These are not routes that employers will typically come across, as the individuals who apply under these routes are usually coming to start up a business or invest funds in the UK, so they don't typically undertake work. But just for completeness, we've mentioned this in here, as that will be extended to EU and Swiss nationals from the 1st of January. And finally, some of the routes previously known as Tier 5 will remain in place, so youth mobility will continue to be there, although this is going to be extended to some other countries. Sports person and creative sector visas will continue to be in place, and so will government authorised exchange, and UK ancestry will still be there. So there's still a good chance you will come across employees with these visas from time to time. So I'm just going to briefly talk about key takeaways from today's session. The main one is to apply for a licence now if you don't already have one. Processing times for a licence are currently still at 8 weeks. This is a service standard and has been for quite some time. However, with everything going on with COVID, we are starting to see a slowdown on the speed of UKVI processing these. For example, in Q3 of 2019, 90% of applications were being processed within 4 weeks, and it wasn't unusual for employers to get their licence back in that kind of period. However, for Q2 of 2020, we've already seen that figure drop to 70% of applications being processed in that time frame. So we're already starting to see a bit of a slowdown happening. COVID has also postponed compliance visits, which means that if you are selected for one, there's likely to be a backlog, which will in turn mean that your licence will just take longer to get. So the quicker you make an application, the quicker you get in the queue for those compliance visits. And also, if your application is regarded as complex, then you're not subject to the 8-week standard processing time, so it's possible the licence could take even longer. So the key thing to take away is, if you think you're going to need a licence, apply as soon as possible to give yourself the best chance of having it in place for the 1st of January. It's also worth just noting that the current sponsor management system, which is the electronic system that sponsors log on to undertake the sponsorship of migrant workers, won't actually change until 2021. So it will continue to be as it is for now, but there will be a change coming to reflect the changing rules. But if you already have a licence in place, it will automatically transfer to the new type. So there's no reason to kind of delay doing that. You will automatically transfer over, but your expiry date will remain the same. It's also worth bearing in mind that even if you're an employer who doesn't think you can sponsor or offer highly skilled work, if you think that you will be able to sponsor medium skilled jobs on the 1st of January, the window is now open to get your licence in place for that. So even if you can't sponsor right now, you can apply for a licence in anticipation of sponsorship from the 1st of January. Some other key takeaways just to think about is, if you have a licence, we recommend that you audit your compliance and right to work processes. For employers that have a licence in place, you will be aware that there are lots of compliance obligations on sponsors, including record keeping and reporting obligations, as well as right to work. UKVI do expect employers to take these obligations seriously, and if you're found to be in breach, UKVI can take action up to and including revocation of your licence. From the 1st of January, we're expecting employers to become more reliant than they already are on sponsor licences, so making sure that you've got processes in place and that you're complying with your compliance obligations will mean that you've reduced the risk of any action being taken by UKVI. Another thing to think about is ensuring that your staff that access the sponsor management system or are involved in recruitment, so people like your level 1 users, are up to speed with the changes in the rules. You want to ensure that they are not going through a resident labour market test unnecessarily or excluding applicants from the recruitment process based on the old resident labour market test rules. And finally, we're now kind of in the transition period between the old system and the new system. So even if you're undertaking the kind of preparation work to sponsor someone from the 1st of January, as long as the sponsorship happens after the 1st, it's worth bearing in mind that the new rules apply and you don't have to go through things like the resident labour market test, which is a big benefit, even if you're kind of applying for the costs and things in advance of that. So it's just worth bearing that in mind. So some closing messages just to sum up today. It is expected that there's going to be a significant increase in the number of organisations who will be involved in the sponsor process and have to know a bit about sponsoring migrant workers, particularly for those who've typically recruited EU workers. At the moment, the number of sponsored workers in the UK, the number of sponsored licence holders is at 29,000, which is one of the highest numbers it's ever been at. And some recent statistics indicated that 90% of SMEs in Scotland haven't used the system before, and we're very much expecting that to change because sponsorship will become a lot more common as the EU freedom of movement comes to an end and EU workers become subject to the rules for the first time. For those who are familiar with the current points-based system, a lot of what's been spoken about today will come as good news. The rules are simplified, they're faster, and everything should be a bit easier and more certain than under the current points-based system, which is good news. But despite that, most businesses will still need help with the process, particularly those who have never gone through it before or are applying for licences for the first time. Some of you might be aware that the immigration rules and rules on sponsorship change frequently, and as mentioned, the implications of getting it wrong can be serious, particularly where a licence is critical to your business. So that's the end of the presentation, and we're now open for any questions anyone might have. I think we have a few, so I'll just go straight ahead with some of these. So one of the questions we have is, do you think that the move away from having different types of certificates of sponsorship will make things much easier from a practical perspective? And do we know if the guides online will be updated to take account of these changes?
So yes, I think it will be more simple and straightforward just having a single type of certificate of sponsorship, because at the moment a lot of I guess individuals accessing the system would have to first of all figure out if they're dealing with a restricted or unrestricted. You've got two different sets of processes and two different sorts of rules that apply. So yes, once that's streamlined and there's just one type and one single process, that will be easier. And that's been one of the compliance problems some organisations have come across in the past if they've issued their own type of restricted or unrestricted certificate of sponsorship to people that, that's caused problems before. But yes, there's lots of online guides on the UKVI website about how to issue restricted and unrestricted certificates of sponsorship, etc. So yes, that should all be getting updated and should hopefully go live in advance of the new rules. But yeah, we're still waiting for lots of guidance and things to come out. But I'm sure they'll be working on that in the background. I think we've got some more questions coming in. So here's one: immigration skills surcharge is very costly. Do employers have to pay upfront for the visa duration? And is there any refund if the employee leaves employment before the visa expires? Erin, do you want to take that?
Yeah, so the immigration surcharge does have to be paid up front. It's paid at the point that you assign the cost to the individual. So when you come to kind of assign that to them, you've got to pay it all at the one time. The amount you pay depends on the length of the visa you're applying for. So if you apply for a 3-year visa, you pay the 3-year charge. If you're applying for a 5, you pay the 5-year charge. If the employee was to leave employment before the visa expires, you can apply for a refund. And the government have got some guidance on this. I think you just make an application online to say that the individual has left your employment and they process the refund, I think in 6-month bands. So you maybe don't get it down to the exact pound, but I think you get a kind of prorated bit back for each 6 months that they didn't fulfill of their original visa.
Thank you. Here's another one. If somebody's coming to the UK from Japan in January 2021, will we still be able to use the old system, or would this automatically transfer onto the new system? Do you want to take that one?
Yeah, so if their employment is starting after the 1st of January 2021, it will be the new rules that apply. So it will be the rules that are no resident labour market test and the lower skills threshold and things. You use the same SMS system as you did before, but it's just the requirements will be slightly different. And when the systems all change later in 2021 or potentially into 2022, this will all be transferred over as far as we understand.
Yeah, and I think we're still waiting for some of the, I guess, the detailed guidance about this sort of handover period. They were saying that access to the new rules, I guess, or the new, applying or issuing for a certificate of sponsorship under the new rules would open, I think they originally said in the autumn, but that hasn't yet happened yet. So towards the end of this calendar year, I would have thought there'll be a mechanism to allow people to apply for a certificate of sponsorship for a situation where somebody's going to be entering the UK on or after the 1st of January. And I think that will be the sort of relevant cut-off date. There's another one here.
Yeah.
Can you explain what employers who currently have EEA employees should be doing to check those employees are eligible to remain in the UK and to continue working for them? So I guess that's about right to work checks. Erin, do you want to?
Yeah, so European or EEA nationals already in the UK may be eligible for the EU settlement scheme. So I suppose the stuff we've spoken about today is just in relation to EU nationals coming to the UK for the first time after the 1st of January. If EU nationals are already here, they can apply under the EU settlement scheme, and that will provide them an ongoing right to work following Brexit, the end of the transition period due to Brexit. And at the moment, it's the scope to apply for eligible individuals, although they have to be in the UK by the 31st of December, they can continue to apply up to the middle of June, I think it's the end of June 2021. So there may be numerous EEA employees who have a right to be in the UK following the end of the transition period, but they don't necessarily have their settlement scheme permission in place yet. We're expecting the government to provide some more guidance on what will happen and what checks employers have to do. But at the moment, EEA passport continues to be relevant for right to work checks.
Yeah, and I think we're anticipating that right to work check requirements may change from the 30th of June next year. But during that grace period from the 31st of December to the 30th of June, employees won't have to produce evidence of having applied through the settlement scheme. But as of 30th of June onwards, that position might change, and we're expecting, up-to-date right to work guidance from that point on. So that takes us right up to about past. So I think I'll close the session there. But if anyone's got any other questions that they think of later, please do send them through. Our contact details are on the slides there. I'm happy to have a chat with anybody if they've got any queries arising from the session. But thank you very much for joining. Thanks.
Thanks, bye.